on. So we have the latest filings in the litigation against Illinois' gun ban that was enacted on January 10th of this year in the Southern District of Illinois. 4 plaintiffs groups filing individual responses to the states when it comes to the challenge against Illinois' ban on certain semi-automatic weapons, magazines over certain capacities, and the gun registry that's supposed to start up in October with a deadline of January 1st of 2024 for you to register your semi-automatic weapons with the states or face a felony charge. So obviously we've been tracking this since January 10th, and even before that, during the debate of all of this, somebody on YouTube this morning, by the way, good morning everybody there, saying it's now day, 74 of the assault weapons ban. Others saying, hey, they're listening from Cook County. They need a vacation from that county. And speaking of that, I am taking Monday and Tuesday off. So just a programming note, I will not be live Monday or Tuesday morning. We'll be back at it Wednesday morning with the very latest, and I'm sure there's going to be plenty of developments between now and then, but we'll obviously track that. I just won't be here live Monday or Tuesday. So I wanted to make sure everybody knew that. But let's get right into it with the latest filings. This coming from the Southern District of Illinois, where yesterday you had filings in these cases. The Barnett case, which is the case with the National Shooting Sports Foundation. You've got a case from Langley, which is out of the county of Crawford in Illinois that was started as a state-level case, but then was transferred to federal court. You've also got the plaintiffs group from the Federal Firearms Licensees of Illinois making a filing, and a case that's named Caleb that I believe is being also Harrell, I think, as well, being led by the Illinois State Rifle Association. Might be wrong on all the associations that are involved there, but either way, we're going to kind of look at the overview of what these filings are. So let's go ahead and start this with the Caleb case, or rather, let's start with the Let me pull this up, just make sure that we're right. The Barnett case. Okay, yep. So the Barnett case, you can see here that they give an overview of kind of a table of contents of sorts. And when you look at these, you can kind of get a sense of what's going to be inside of that. So let's just read through some of the table of contents. They argue against the state's gun ban, saying that it's unconstitutional under the Bruin decision from the U.S. Supreme Court last summer. They go on to say that the firearms listed in the state's law are arms within the plain text of the Second Amendment. What is that plain text of the Second Amendment? A well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. That's the text of the Second Amendment. So it goes on to say that the state has not historically justified a firearms ban. And they also say that the banned firearms are in common use for lawful purposes, and historical restrictions on dangerous weapons do not support the state's firearm ban. The state's additional policy arguments are irrelevant to the historical analysis of the firearms ban, and they go on further to say that the magazine ban's unconstitutional under Bruin. The other factors justify an injunction against the law, and they're saying that final judgment is appropriate. So that's just an overview of the Barnett arguments. Let's see if we can get the Langley case here loaded up for you to give you an idea of what exactly they've got going on with their arguments. And again, these were filed yesterday in the Southern District, where they've got 4 lawsuits in that federal court queued up for a April 12th hearing in East St. Louis. So the Langley case here, they argue that the constitutional rights are not extinguished by hyperbole. This is interesting because you hear a lot of the irreparable harm arguments being that the other side that wants to have gun control. Well, there's all these mass shootings that are happening. We need to limit the access to firearms. But the Langley case arguing essentially that constitutional rights can't be extinguished by hyperbole, by facts and figures, and so on. They also talk about how arms that are in common use in the 1700s and at the time of the 14th Amendment, they talk about what that ultimately is defined as. They go further to talk about magazines are arms deserving of Second Amendment protections, and they make that argument there as well. They also discuss that the restricted arms in the state law include many defensive arms. And then they go further to discuss the Bruin two-step. And I want to kind of just unpack a little bit. They say, getting to the actual applicable legal standards, defendants claim that the plaintiff's claims fail Bruin's second step. And they go on to say that the act responds to an utterly modern concept born of dramatic technological change, mass shootings perpetrated by lone individuals armed with assault weapons and large-capacity magazines capable of carnage at a level inconceivable of the framers of either the Second or 14th Amendment. They essentially go on to argue that that's inapplicable. And, of course, the conclusion is that, they say that 15-round magazines were available 100-plus years ago, and that's not new, the idea of 15-round magazines. The Langley case also goes on to say, also not new, mass killings. They say that 27 people were apparently murdered 10,000 years ago, as described by Smithsonian Magazine. So they provide some various things like that. Murder is not a recent invention, as the court can take judicial note of that. So an interesting argument there, essentially saying that these weapons aren't new, and neither is mass killings. Those aren't new either. We'll get to some more of the pleadings that were filed by the plaintiffs groups. Again, 4 plaintiffs groups in the Southern District of Illinois. This is the federal level. This isn't the state level cases, right? You've got divorce cases, 3 of them combined, thousands of people with temporary restraining orders that are safe from the state enforcing this gun ban on them, including the gun dealers. So you've got those cases. You've got the Macon County case, state level, that's going to be heard by the Illinois Supreme Court in mid-May. But we're talking about the federal cases, and the filings, most recent, being from the plaintiffs' groups responding to the state, essentially saying that the state's wrong in banning guns because of the Second Amendment. So we're going to continue to look at what the Federal Firearms Licensees of Illinois have to say, and also what the Caleb plaintiffs group has to say as well. It's all coming up here with Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, and at any time you can call in live and local at 217-629-7970. Again, 217-629-7970. That's the phone number. So we'll get to that coming up next. Back with Springfield's Morning News, I'm Greg Bishop on WMAY. You can also find me on Twitter. Just search Bishop on Air. A lot of you watching online at various places, be it YouTube, Bishop on Air, or you can also watch us live on WMAY News on Facebook, Bishop on Air on Facebook, also on Twitter, Bishop on Air as well. We've been taking each and every morning practically in the start of the show to review what's going on in the latest litigation against Illinois' gun ban. It's been in place since January 10th. The YouTube user noting it's 74 days now. And one thing that we have last night is 4 different filings from plaintiffs groups responding to the state's response that the state's ban on semi-automatic weapons and magazines and a gun registry violates the Second Amendment. Wanted to just jump back into the Langley case, where they make the argument that the constitutional rights are not extinguished by hyperbole, and just read this for you. More recent vintage than the hydrogen bomb. That's how defendants categorize firearms banned by their ill-conceived statutes, as if we're talking about thermonuclear devices with special cobalt-lined cases a la the Castle Bravo test. Such hyperbole, conflating weapons powerful enough to destroy entire cities with common and ordinary firearms, is not becoming of state officials or their attorneys. It's also a flat-out falsehood, like much of their argument. Hydrogen bombs or thermonuclear bombs were in fact developed after the kinds of firearms at issue in this case. The first thermonuclear explosion in November of 1952. They are much more complicated than firearms at issue, some of which can literally be made by hand over a campfire. On the other hand, defendants in the list of firearms banned by the Illinois state statutes includes a Mauser 696 that was made in 1896, a broom handle pistol. Also, Winston Churchill literally carried such a firearm during the Boer War of 1899 while serving as a war correspondent. Other such banned guns and magazines that are also predates thermonuclear weapons include the M1A1 paratrooper carbine of World War II vintage. They go on to describe that more. So interesting to see those arguments in the case that the Langley plaintiffs brought forward. Let's take a look briefly at the Federal Firearms Licensees of Illinois arguments, and they essentially break down saying that the state misreads the Heller decision, and the act is in defending its rifle ban. So they obviously are highlighting some of the more intricate details of the Heller decision. They also go on to talk about the reference to M16s and the like is irrelevant from the state's stance. The state's M16 comparison misunderstands firearms and its own law. The state also resorts to a more nuanced approach to analogical reasoning, and it fails, the FFLIL group says. The banned arms do not represent a dramatic technological advancement. They also say that might justify a more nuanced approach, but they say that the relevant history and tradition does not support the state's modern ban on protected semi-automatic firearms and magazines. They say 19th century laws regulating dangerous, unusual weapons are not relevantly similar to the state's modern ban on firearms and magazines in common use. And they say that the state's reliance on 20th century machine gun laws is unpersuasive and factually wrong. So again, those are just some of the overarching arguments that the Federal Firearms Licensees of Illinois are making in their response to the state's gun ban. And then finally, you got the fourth plaintiffs group here under the name of Caleb, and they give an overview as well. They say plaintiffs are likely to succeed on the merits, the plaintiffs being those challenging the law. They say that the firearms and magazines that House Bill 5471 bans are arms. They go on further to say whether something is an arm is different from whether it's in common use today. Whether something was in common use in 1789 or 1865 makes exactly zero difference. They go on to argue whether a particular type of bearable arm is necessary for self-defense is irrelevant. They say that the arms that HB 5471 bans are typically possessed by law-abiding citizens for lawful purposes, including self-defense and sporting. And insofar as the burden shifts, the government cannot shoulder it, they say. The remaining factors all favor injunctive relief. So when can we see injunctive relief? It's a great question. Of course, you've got the filings being made on each side. We've gone through the thousands of pages that the state filed in response to the preliminary injunction, and then also all of the answers that the state gave to each of the plaintiffs' groups. And then now we've got the plaintiffs responding to the state saying that their gun ban is unconstitutional. So you've got now the march towards the April 12th hearing in Southern District Court in East St. Louis with Judge Stephen McGlynn, where they're going to hear each side of these arguments. It could take all day, right? 3 or 4 hours possibly. Who knows? But then after that, there's a couple of options here. Number one, the judge could rule from the bench. It happens. It's not unheard of. Will that happen in this case? Will the judge say, all right, we're granting a preliminary injunction right now? Is that what's going to happen? I don't know. He could say, hey, we're going to grant that preliminary injunction. That's a lot of observers saying, no, we're not going to see that. Instead, what might happen, what's considered to be more likely, the judge will take it under advisement, meaning he's going to sit on it, he's going to review things a bit further, and then make a decision about a preliminary injunction, which would halt the law for everyone statewide if a preliminary injunction is granted. Now, if it is granted, there's going to be an appeal from the state you can anticipate, and that'll go to the appellate courts in the federal districts. Or if the judge doesn't grant a preliminary injunction, the plaintiffs' groups likely are going to appeal all the way up. And even the judge, Stephen McGlynn, he's recognized this in a hearing they had several weeks ago to consolidate these 4 plaintiffs' groups. The judge said that ultimately this is going to be appealed all the way up. He recognizes that. He also said he didn't want to be papered to death. but we've seen plenty of paper thrown out in this case. So it'll be interesting to see how the judge ultimately handles all of this and juggles all of this whenever they have that hearing April 12th. So that's the latest here on the 4 plaintiffs groups that filed their response to the states over the ban on 170 plus semi-automatic weapons, shotguns, pistols, rifles, magazines of more than 15 for handguns or more than 10 for rifles, plus the gun registry that some people point to being a violation of the Fifth Amendment right to not incriminate yourself. That's not at issue here. That could be brought up at a later date. Right now, only at issue in the federal court is the allegation that the ban on weapons violates the Second Amendment, because these weapons that they list as banned, especially AR-15 style rifles, are very popular, very common, and held by law-abiding citizens. So we'll see how these arguments play out in the coming weeks, and we'll bring you the latest here on WMAY. It is Springfield's Morning News. I'm Greg Bishop, and you can always chime in live and local at 217-629-7970. That's the phone number on WMAY.